I'd like to call to order the City of Oak Harbor's Planning Commission regular meeting, October 25, 2016. For the record, all the commissioners are present except Commissioner Freeman. Second on the agenda is the approval of the minutes. Do I have a motion?
I would like to make a motion to approve the meeting minutes from September 27th as presented.
I second the motion.
Motion's been made and seconded. All in favor?
Aye.
Aye. All opposed? Approval of the minutes passes. Item number 3, as we do at every meeting, the Planning Commission will accept public comment for items not otherwise on the agenda for the first 15 minutes of the Planning Commission meeting. And seeing no one in the audience except staff, I will close that part of the meeting. Item number 4, public hearings and meetings. The first item is the Marin Woods Planned Residential Development, PRD, and preliminary plat. As we all know, this was a continuance of the public hearing that began at the meeting on September 27, 2016. The Planning Commission will be asked to continue this hearing until December 13th, 2016. Do I have a motion?
I move that we continue the Marin Woods subdivision application public hearing to December 13th, 2016.
A second?
I second.
All in favor? Aye.
I think we want to have the record reflect that there's one abstention, Mr. Wassinger, because
Oh, yes, of course.
Jess Walker-White.
Jess
I
Walker Wise
abstained.
Because she was recused to the last meeting for that particular item. Item number 2 is the Model Homes Code Amendment. This is a public hearing. It was scheduled for 9/27 and was set aside until this meeting. The Planning Commission will conduct a public hearing to consider a code amendment to allow for the construction of a limited number of model homes within a subdivision before that subdivision's final plat has been approved. I here open this public hearing.
Thank you.
Ray,
Thank you,
you're on.
Commissioners.
Thank you.
Ray Lindenberg, Associate Planner. We are here tonight to take a look at the Model Homes Code Amendment, as it is known. Pretty much what we're looking at, a little background, is that this change was requested by a local developer to allow them to do construction of model homes before that final plat approval is done. Right now, what you have is a situation where you're going through that process of getting a subdivision done. You only have one lot until the subdivision has been recorded. So therefore, you could only build one house. That's kind of limiting for a developer who wants to put some model homes out to show off his different designs and be able to have buyers come in and take a look at those. So what the concept here is to allow for multiple homes to be built on that one lot in advance of the actual final plat approval. So that's the background of that. Like I said, there is the way that it's set up right now. We just limit it to the one single family home on the parcel. The purpose of this is to draft the proposed zoning regulations to allow for up to 9 model homes to be constructed prior to final plat approval. The reasoning behind that number of 9 is so that if something were to happen that this final plat doesn't go through, the 9 is the cap for how many lots you can get with a short plat. And so you could go through and do a short plat on it if something were to fall through with the subdivision recordation and be able to still have lots for each of those homes. The homes are to meet the criteria that are set forth in the proposed code that we have in front of you, and also they'll be required to meet the existing criteria. In other words, you're not going to have homes with lesser setbacks or smaller lots or other things that might be contrary to our existing code. When these are done, you won't be able to tell the difference between these homes and any other house that's built in a subdivision to our standards currently. Another key thing is that staff was concerned about is that the stormwater facilities need to be in place and approved prior to the construction of any homes. When you build a house, it's going to create water runoff, so we need to have that all in place and approved and ready to go. Also, access needs to be provided for life safety needs as well as the ability to show the homes for customers, potential customers. Water and sewer connections will be required in order to provide them with proper sanitation. The builder and developer will be on notice that the model homes are subject to removal if the final plat approval is not granted or the preliminary plat approval period expires. So there's always that kind of hanging over that if for some reason that they don't go through the proper channels, the proper steps to get this done, then those homes could be removed. And then financial securities will be required of the developer in the amount of 150% of the contractor's estimated cost to restore the site to its previous condition in the event of a failure to meet the conditions that are set forth in the proposed and that sentence doesn't work real well, sorry. The conditions that are set forth in the subdivision, as well as any other applicable regulations that go along with that. So the code amendment criteria, the process by which the amendments are made to the Oak Harbor Municipal Code are governed by OHMC 1980. The two criteria that are considered for amendments are A, the amendment must be consistent with the Oak Harbor Comprehensive Plan, and B, that the amendment must substantially promote the public health, safety, and welfare. And staff determined that both of those criteria are met, and so we are recommending approval of this ordinance to the Planning Commission tonight.
Thank you, Ray.
Yep.
Any other public comment at this time? Public comment. We're going to close the hearing. If there's no public comment, then we can ask questions of Ray. So I'm going to close the hearing now. Okay, Hal?
When you say restoration costs to the original condition, I mean, that could be pretty wildly interpreted, what the condition was.
Yeah. Essentially, I think what it's saying is that the removal of the home, the removal of improvements that went along with that, any construction that occurred.
So removal of roads,
get there.
sewers,
Yes.
water lines.
Yeah.
Wow.
And honestly, it's a big hammer to
Yeah.
kind of ensure that this goes forward and they follow the process and get it done correctly.
Thank you.
Was it Mount Vernon that already had something like this in place?
Yeah,
And
yeah.
is that code provision, the restoration, is that similar to what they had
Yes.
in their code?
Yes, it is. Yeah.
Okay.
It's actually exactly what they have.
Oh, well, why reinvent the wheel?
Eric, you have?
Yeah, I have a question regarding occupancy. While there's an instrument recorded against the original parcel that conditions that removal if permitting isn't achieved. But then later on, we talk about occupancy, where the applicant can request final inspection and occupancy of residents for one of those properties. That seems to me like it'll pose a challenge for lenders or title companies to lend and insure on that property if the property is subject to removal. Has that been considered?
The homes won't be sold to private homeowners until the final plat is recorded, so that would go away at that point. The concept here is to allow for the construction of the homes to begin and for them to be finished in order to show the finished interiors and what they look like and everything, but they won't be sold to private homeowners until the final plat is recorded.
So maybe I'm reading the occupancy section incorrectly, but it says they may request final inspection and occupancy as a residence for one model home prior to subdivision. So if they're allowed to create multiple model homes, but they're only allowed to get one, I guess I'm a little confused.
Do you mind if I jump in? Would that
Sure,
be okay?
go right ahead.
That follows in line with what happens under our current code right now, or what could happen under our current code. Again, so that idea of one big parcel, and you're allowed one unit per parcel. So they would be allowed to get occupancy for that one home because they still have the right for that one home on that one large parcel. But only that one, and any subsequent occupancy would require the actual final plat. So in a case that I think that you might be worried about, you can always, that one home wouldn't be subject to removal because it already has the underlying property right of being able to be on that piece of property.
Okay. And they will not be required to get an occupancy permit for additional model homes, correct?
No.
They can show model homes without an occupancy.
Without
Permit,
a
kind of
final occupancy permit where you have the family living in it. Right. They'll be able to utilize it as the model home itself. So it'll be legal for the salespeople to be in there, but it won't be legal to be used as a home.
Thank you.
Any other questions, commissioners? Thoughts, comments? If not, I would entertain a motion.
I move that we recommend approval of the draft ordinance number 1780 to the city council.
I second the motion.
It's been made and seconded. All in favor?
Aye.
Aye. All opposed? Motion passes. The next item is low-impact development. This is also a public hearing, and Dennis Lefevre, senior planner, will take us through this. I would like at this time to open this as our public hearing. Dennis?
Thank you, Mr. Chair, members of the Planning Commission. This item certainly is not new to you folks. We've had this in front of you for several months now on various occasions dealing with certain aspects of this project. But as we have discussed in the past, and what I'd like to briefly bring forth again is kind of why we're at this point in our discussion with low-impact development. Oak Harbor is a Phase 2 city under the National Pollutant Discharge Elimination System. That system was created under the Clean Water Act back in the early 70s, and the EPA has given the Department of Ecology authority and administration to run that system in the state of Washington. The Phase 2 cities, which we are required to be in conformance with permits, which are issued, I think, every 4 to 5 years, and include about half a dozen major categories in the permit, including such things as making sure that we monitor and identify locations of illicit discharge. We need to have a public education and outreach program for how we deal with stormwater and cleaning up our waters. We also have to have or meet certain requirements for our operations and maintenance programs for our water facilities. And the other big one is controlling runoff from new development, redevelopment, and construction sites. So every 4 or 5 years, this permit comes out with requirements that we must be in conformance with dealing with those above topics. In the 2013 National Pollutant Discharge Elimination System, NPDES, permit required that we review, revise, and make effective codes and standards incorporating and require low-impact development best management practices and principles within our code. And of course, low-impact development is basically a stormwater management strategy which is focused at treating and infiltrating stormwater at the parcel or subdivision scale. So with that said, we had to look at incorporating these low-impact development techniques into our code. And we've been doing that through the course of pretty much this entire last year. The requirement in the permit also stated that we have to have this accomplished by the end of this year. So Brad Gluth, our civil engineer, and myself have been working diligently for the last at least year. Some of the big steps that we've done is we've developed a core management team to help us kind of guide and give us some feedback on the process as we go through this, this exercise. We've established an internal and external stakeholders group, which we met with several times through the course of this last year to kind of get some feedback from these special groups. And we have reported to you in the past on some of the feedback that we've received from these groups. The Department of Ecology actually prepared a toolkit, guidance document, if you will, that we have been using to make sure that we're meeting the key topics and subtopics that they're identifying that we should address in our code update process. And if you, some of you may recall that in 2011, the city actually adopted a set of amendments incorporating low-impact development into our code. So we utilized that package of amendments as well to kind of build upon with this new set of amendments. The package, or book, actually establishes amendments in 6 of our titles. And obviously, Title 11 is streets and sidewalks. We have Title 17 amendments dealing with buildings. And I'm not going to go through page by page on this document at this point in time, so don't fear that. Title 19, we have some amendments for zoning. Title 20 for the environment, and Title 21 for subdivisions. Title 12, of course, is a stormwater title. That probably has received the primary brunt of amendments that we're proposing. One of the key things that we're doing is also adopting the 2012 Stormwater Management Manual, which was prepared by the Department of Ecology, amended in December of 2014. There's a whole bunch of language in Title 12 that we had to make a conformance with the new manual. So that's probably the biggest title that has received most of the amendments to it. There's a lot of material in here. However, it's a lot larger than the actual amendments. What I did as an approach was, our titles are broken out by chapter, and where there was an amendment to each individual chapter, I included the entire chapter in this document. The amendment may actually be really small in that chapter, but the chapter may be 12 pages. The amendment might be a reference to the 2012 manual in Title 12. So don't let the size really fool you. There's more pages without amendments than there are with amendments. But obviously the red strike through and underline are where the amendments are that I'd like you to pay attention to. We are requesting that you review this information. We are asking also that the Planning Commission make a recommendation to continue this public hearing to November 9th to give you and the public some additional opportunity to review this document. We do have it on our webpage at oakharbor.org for any interested citizens who may want to look at these proposed amendments. Brad, I would certainly offer an opportunity for you to make any comments at this point if you would like to. Okay. And obviously subsequent to our November 9th continuance, and we will be taking it forward with your recommendation to the City Council. So with that, I'll be happy to respond to any questions you may have at this point.
Any questions at this time?
We kind of talked about this at the workshop. I'm really concerned about the impact on quality of life and what it's going to be doing to our city, having all these rules. One of the things I wonder about are we basically trying to do away with storm sewers? Is that part of the objective of this code? I mean, is it going to be something where all the stormwater all has to remain on a property? It can't go anywhere else?
That's the objective of low-impact development, is to maintain and deal with the stormwater on the parcel or subdivision location. It's going to be a transition. Obviously, this will only kick into effect when there's a redevelopment that includes probably about, 2,000 square feet of additional hard surfaces, or new development that encompasses the same amount. But it's going to be a transition. It's not going to all happen beginning of next year. But I think the focus is, yes, to keep the stormwater on the site, not necessarily to do away with our existing system, but to make that transition over time so that we deal with stormwater a little differently than what we are dealing with it now.
So that's where we get into the quality of life issue. I mean, we end up with all these, huge ponds in residential neighborhoods that essentially turn into cesspools in the middle of the summertime, full of mosquitoes and other, critters. And that doesn't seem to me to be a benefit, you know, it may be in benefit to the sound, which is wonderful, I'm all for that, but it doesn't seem to me to help the health of the citizens any.
That's a good point, and it's well merited. But with low-impact development, again, it's not going to be one size fits all in all locations of the city. So there's going to be some flexibility in this code that allows different applications of low-impact development. Some may not even be feasible. There are opportunities where if the soils just are not suitable for low-impact development, there's going to be an alternative that has to be approached, and it could be back to our traditional detention facilities.
Do you mind if I tag on to that?
Yes, please do.
It's a great question, Hal, and I think the phrase that I've heard is pipes and ponds. You know, that's our system right now, or you know, essentially some sort of pipes and ponds, right? So there's some sort of artificial means to convey the stormwater, and an artificial basin created to hold that stormwater. It's my understanding as these techniques would be applied to properties, we're really going to be moving away from that centralized stormwater collection facility to a more decentralized approach. So we'll be seeing the smaller facilities on a lot-by-lot basis, combined with, you know, the use of a greater use of natural areas to handle that stormwater. So we likely won't see the creation of the large ponds that we're seeing today, but we're going to see a greater number of smaller facilities scattered throughout the project. And I glanced over at my colleague to make sure that I wasn't going astray there. And
You're not going astray. There will still be ponds in some instances.
we'll get you up to the mic though, if I think. But I think I know where Brad is going with that. That as Dennis was alluding to before, it's likely going to have to be a combination of all of our techniques, our old techniques and our new techniques, in order to handle stormwater.
Hal, there will still be ponds very similar to what we have now. The LID best management practices will be in addition to those. And like Dennis said, it's not going to be a one-size-fits-all. It's very reliant upon what the existing site soil conditions are, how permeable they are. Some sites will have soils that are just not conducive to LID, and then those requirements actually fall away, and you're back to kind of basically the system we have right now. Some sites that have better soils that perk will have to do those LID BMPs, and they'll still have a pond on top of that. In theory, the ponds will be smaller than they are now, because some of the water will be handled on this decentralized system that Steve was mentioning. We haven't had too big of issues with mosquitoes so far. We have a lot of the ponds. That's always a concern. I don't know if there's much of getting away from it. The ponds have been a system required since 1992. So there's going to be a balance that has to be struck. This is something that's mandated. And what we've tried to do is provide as much flexibility in neighborhood and commercial design as we can, and still honor the letter of the law to say.
So are we going to end up seeing a future where we have, you know, developers coming in and saying, well, I'm going to go with dirt streets and gravel sidewalks and...
No, the code won't allow for that. Well, there will be alternative materials such as pervious pavements where they're appropriate. And like I said, to go back again, it'll rely on the site soils. And the soils aren't the same everywhere, so it relies on heavy site soil investigation up front of the project, and that's a requirement for the Department of Ecology manual. They have to spend a lot of time and energy investigating that site to see what actually works there, then fit the design to those soils. And that's different now. They often try to fit the design to the site, but this is going to put what's there now up front, and it's going to affect designs.
It may seem counterintuitive, but gravel surfaces are considered stormwater generating surfaces. And so moving away from asphalt or concrete to a surface like that doesn't negate your responsibility to handle the stormwater that comes off of it.
That's why I'm worried about dirt roads.
Yeah.
Yeah, no, we won't be having dirt roads.
Yeah.
Maybe pervious concrete or pervious asphalt.
So Brad, are there any major, I should probably know this, commercial undeveloped properties in the city?
Yes.
And if there are, is that
I'll just
going to be
yes.
able to be dealt with like a Home Depot in the past, or?
Yes, and we're going to see that situation. I mean, if we think about some of the vacant parcels here in Oak Harbor, each of them has unique characteristics. The vacant parcel between the Whidbey Island Bank and the 7-Eleven on the south end of town, while not tremendously large, is by Oak Harbor standards a fairly large commercial piece of property. We have some, semi-large pieces along the northern end of town on the highway. If you think about the generally SR20 Northeast 16th Avenue area, particularly the northeast quadrant there. Perhaps more predominant in our community are underutilized commercial parcels. So there are quite a few parcels, again, many with highway frontage, that probably by any objective standard are underutilized, and when we see those redevelop, in other words, with a more intensive use, then these standards will all come into play. And so going back to your example of the Home Depot, or the reference to that, that project, along with those pads that were developed in concert with it, utilized in part that large stormwater basin, right? That approach will be significantly different, assuming that the soil conditions will allow it. And then also even the number of parking spaces and the types of pavement that are used, it would look significantly different than what it does today.
I've seen some neighborhoods in the King County, Snohomish County area that have used LID development, and they can do some very creative things that look very aesthetically pleasing when they're designed to those standards. My biggest concern is for existing neighborhoods and what will happen. And I know you've mentioned the addition of more than 2,000 square feet of hard space, and I struggle to find that within this packet. So if you can refer me to where that is, because what I see in 12.3 in the exemptions, or just before exemptions, it talks about a substantially developed site with 35% or more existing hard surface coverage. When somebody's applying for a building permit, that section is triggered. So I'm not finding the 2,000 square feet section. But my concern is for a neighborhood that has not been developed to these standards, and then a homeowner or an insurance company is triggered into low impact development to rebuild or to make additions. How are they going to structure that new construction within an existing building envelope that was not designed for low impact development? Does that make sense?
Yes, so I'm going to try to find the section about the 2,000 square feet of hard surface. Pretty sure it's in there.
Yeah.
I believe it was in there the other day. So Dennis is going to look for it. So
Sure.
it's not going to affect existing neighborhoods much because they're already developed. So if somebody were to build on an undeveloped lot in an existing neighborhood, if they exceeded that 2,000 square feet of hard surface, they would trigger, generally what that house would trigger would be a rain garden in the yard and pervious pavements for the driveway and walkways around. If they had instead of like a flagstone patio or a concrete patio, they'd have a pervious concrete patio or pervious pavers, which are aesthetically pleasing. So that's not that hard to accomplish. So Dennis is pointing me to page 28 of 49 in Title 12, subchapter 1230.5, minimum requirements. Yeah, I'm looking for the language.
It's in redevelopment. It's 12.30.515. I think Eric addresses the scenario you were describing for us under the redevelopment section.
Okay, so in that section that Steve just cited, 1230.515 redevelopment, item 2 says the following redevelopment shall comply with minimum requirements number 1 through 5 for the new and replaced hard surfaces in the land disturbed. The new plus replaced hard surfaces results in 2,000 square feet or more, or 7,000 square feet or more of land disturbing activities. So it's 2A. And I think we need a little bit of wordsmithing on this.
Does that include the roof of a home?
Yes, it does. So hard surfaces, impervious surfaces, which has been a trigger since 1992, and it's pervious pavements, and it's vegetated roofs. So a roof, it falls under the impervious surface definition. Hard surface encompasses impervious surfaces, pervious pavements, and vegetated roofs.
Brad, without putting you too much on the spot, would it be possible for you to give us a general sense of what minimum requirements 1 through 5 are?
Okay, yeah, 1 through 4 are pretty traditional of what we've had for years. That's not a big change from previous DOE manuals. Number 5 is a big change. Number 5 has 2 lists in it, and the developer gets a choice of where they pursue a list of low-impact development best management practices to pursue from top to bottom, starting with the top one, and if it's infeasible, they go to the next one down, and so on until they get to a point where either a low-impact development best management practice is feasible for that site. And these lists apply to yards. There's 3 subcategories in each list: the yard, the roof and its runoff, and then pavements. So there's lists for each one of those categories. And for each surface, the yard is pretty easy. It's basically you have to amend the soils so they have so many organics, a certain pH content. The roof has a list of low-impact developments, and the first one that's generally going to be feasible for a development in this city is going to be either bioretention or rain garden, which are almost the same thing. A bioretention is an engineered rain garden. It's proven mathematically to a higher standard that it'll work. And that is for larger developments. So smaller development, they can just do a rain garden. That's going to be the first thing that's feasible on most projects in this community if the soils are sufficient. For pavements, the first thing is dispersion, which is not going to be feasible because it takes a huge amount of land to meet the dispersion requirement. So the next thing is pervious pavements. That's going to be the workhorse for most developments. I believe if pervious pavements aren't feasible, then you can go down to bioretention, where you do a traditional pavement and run it off into bioretention, which means you have a lot of bioretention alongside the road, lots and lots of it linearly along the side of the road. So in 1 through 5, the big ticket item is minimum requirement number 5. It has these lists in it. Now, there's a choice. The developer does not have to use those lists. There's something called the low-impact development performance standard. And it's very much an engineer's thing. It's a mathematical detention requirement well above and beyond what we see now. So it makes ponds huge if they choose that requirement. And according to the Department of Ecology, to meet that requirement, which is a choice, they can choose the list, just go down through the list, say what's feasible, and implement that. It's prescriptive. Or they can choose this LID performance standard. The performance standard, according to Department of Ecology staff, is infeasible to meet. They cannot accomplish meeting that requirement with a pond alone. They would have to have lots of LID, BMPs scattered around through the property, and significant infiltration, like an infiltration pond or very permeable soils. So if they just pursued a detention pond to meet that requirement, according to DOE, it's impossible to do. So I suspect most developers will choose to do the list because that's kind of the easier prescriptive pursuit. Now, there's going to be times where somebody has an engineer who wants to be creative, or they want to be creative, and maybe they want to pursue alternative low-impact development best management practices that are not on the list, such as a green roof. There are other things. There's certain foundations that perch the building above the ground. You can run the rainwater onto the building. It's kind of like an old cabin where the cabin's up in the air on posts. There are other options they can pursue in that low-impact development performance center, but they have to quantify a lot more. It's a lot more hydraulic modeling. I think most developers and their engineers will pursue that list. The minimum requirement number 5 is actually the biggest change in this new manual.
So that's a good summary, I think, of those techniques, particularly as they would apply to new development on a single-family lot that already exists. Obviously, we'll have to see how this works, on a case-by-case basis, but, looking at this, I would suggest that the 2,000 square foot threshold is actually fairly large when we think about that the minimum lot size for a regular, straight, single-family lot in town is 7,200 square feet. So that's more than, that'd be adding more than 25% of the total lot area right now in hard surface. And so probably a good question as to whether that threshold would be tripped on a reoccurring basis.
It could be somebody could stay under that threshold if they wanted to, just with the architecture of the house. You want 2 stories and a driveway, depending on their driveway length, they could stay under 2,000 square feet of hard surface if they wanted to. But I don't think it's gonna be that big of a challenge to get a rain garden in a yard for a single-family house and doing pervious pavements. It's different. Those pervious pavements for the driveway and walkways have to stay there forever. They have to be maintained. The rain garden has to stay there forever and be maintained. That's going to be different for a homeowner. That's going to feel different to them because they're used to be able to do their own landscaping. And the rain garden will be something that is protected through a covenant, and there'll be easements so that staff can inspect it, make sure it's being maintained and functioning and preserved.
How will this affect developments that are existing that have a number of undeveloped lots? Has that been met at some point? Are they grandfathered, or do
I'm
they
going to
have?
look at Steve here, but I think those are vested under the old system because they have a system. If it's a plat that was developed recently, they have a system that was built and approved. So they're just pulling a building permit and building a house with more of a traditional stormwater system with detention. If it was a very old plat that didn't have a system, maybe it's from 50 years ago and there's no system, it would fall under the LID.
But the direct answer to your question is yes, they would be vested in the development regulations that were in place at the time that the project, technically at the time the project was determined to be complete. We've talked
So
about
in other
that.
words, if you had a lot that is undeveloped and it's 16 years or 18 years, it would still fall under the guidelines of what?
As long as we had that
One, two.
existing system, yes.
Okay.
And for those areas which are in a portion of our community where there is no system, so we may need to be looking at that in a slightly different fashion. And I think really one of the answers that I think we're giving you through a lot of these different questions is that there are going to be a lot of sort of unique situations that we're going to have to figure out how does this code really work. And it's an uncomfortable position for staff to be in, and you heard me make that comment at the workshop that we like to bring you a code that we can tell you more or less this is exactly how it's going to work. This is not one of those times. I think the saving grace for us here, and Brad alluded to it earlier, or maybe it was Dennis, is that we're not going to be met with a deluge of these on January 1st. We're going to have an opportunity to try to figure out how does this really work, to work with the homeowner or the property owner to make it as logical as possible as we try to apply these new rules that ecology is requiring us to have in place. And I will suggest, or I think I'm safe in saying that the 2,000 square foot limitation is not one of those areas where we have some local choice or have local
We do not.
flexibility. We're stuck with that threshold. Thanks, Brad.
You're welcome. Any more questions for me?
Thank you. Anything further, Dennis?
No, that's it
This
for
time?
me. Thank you.
Well, then, as per suggested, does the commissioners have anything further this evening? Oh, I'd like to mention that Commissioner Freeman joined us, so now we're a full 7-person commission this evening.
I'd just like to have one comment on the LID that's coming up. Is the biggest thing to remember is there's going to be, when we've discussed this before, where the inspections that the city is going to require a code amendment officer or something like that in order to ensure that the rain the rain pond is still there and whatever impervious surface is laid out, that is still there. So the easements and all that stuff is going to be affecting the homeowners quite a bit. So that's just something to keep in mind. And more codes will be coming up at a later time.
Yeah, that's another aspect that's all part of this is the inspection and the requirement of the homeowner to actually try to maintain this and learn how to maintain it, and our inspection responsibilities, the whole aspect.
Yeah, the policing, if you would.
Yes.
Well, at this time, I would offer up that we need to continue this hearing to the special Wednesday, November 9, Planning Commission meeting. If that's all right with everyone, that's where we'll go with that, okay? So it's still open. The next item, yes, go ahead.
Do we need to make the motion to?
No, I don't
Continue?
believe so.
In this one, it's fine to do it the way that the chairman has done.
Yeah,
Good.
Yeah.
because it's open and
Of note, I believe that starts at 7
Yes,
p.m.
we'll start at 7.
7, no pre-meeting.
No pre-meeting,
Yeah.
but I was advised that asking for a different time might be confusing to staff, so we were going to make sure that we're here at 7 o'clock.
Well, that's sort of the way I looked at it, too. So 7 o'clock works, okay.
Thank you, Commissioners.
Thank you, Dennis. Associate Planner Ray Lindenberg has the sign code, and this is a public meeting, and he's just going to give us an overview at this time, I trust. Ray?
Thank you again. Okay, so I'm going to give you guys just kind of a little background and what it is we're doing with our sign code here. Some of you might have heard about the recent decision from the Supreme Court that kind of changed the paradigm of how we deal with signs. So we'll go through that. If there's any questions, this is not a public hearing, so it's more of a conversation. If you have anything, just holler it out and I'll stop and we can discuss that. So, gonna have problems with this again, huh? I'll just have to read off mine. You guys don't get to see them. So in the recent Supreme Court decision was the Reed versus the town of Gilbert is what it was entitled. The Supreme Court determined that the manner in which a local jurisdiction regulated their signs was unconstitutional because they were based on the content of the sign. Now, it's what we're thinking here is what is a sign? How do we regulate a sign? What is it that makes a sign? And a lot of codes throughout the country, ours included, talks about what's on the sign itself. What does the sign say? And uses that to categorize how the signs are, thank you, that's it, how the signs are regulated. And so this court decision makes it so that we can't do that anymore. We were walking kind of a fine line previously anyway. A lot of different codes talked about, a real estate sign versus a political sign. Well, how do you find out what a real estate sign is versus what a political sign? What it says. And so that's where we run into problems. Now, the town of Gilbert specifically, their sign code prohibited outdoor signs without a permit, but certain types of signs were exempt from that prohibition. They had 23 different categories of signs. That sounds like a lot, but it's not untypical. We have a whole bunch of different categories for signs. Other jurisdictions have lots of different categories for signs because there's a lot of different signs out there, and how you handle them is going to depend greatly on what you want your community to appear and how you want it to appear and what you want to say. So each category was subject to different regulations, including the size, the timing, and the location. So it talked about how big the sign could be, how long it could sit there, and we're talking about temporary signs right now, and the location of the sign, where it could go. I'm going to keep going. In the specific case of the town of Gilbert, a church was cited after advertising a time and location of its Sunday services using temporary signs at various locations. They used off-premise signs. They stuck them in the ground. They didn't have a permanent location, so they put out their signs to let their parishioners know where to go and what time. The church was cited based on regulations for, quote, temporary directional signs relating to a qualifying event. That was the category. Which were different and more stringent than the regulations for other categories of signs, such as ideological or political signs. That's where you run into the problem. It's content-based. The church sued, and it ended up at the Supreme Court level. The argument was that the sign code violated their freedom of speech under the First Amendment. Now, the problem with that, like I said, was the content-based regulation. The majority opinion of the Supreme Court found that the distinction between the different sign types was content-based and unconstitutional as a violation of their First Amendment rights because the town of Gilbert could not satisfy what we call strict scrutiny. Now, strict scrutiny, I'm going to read a definition that comes out of a legal dictionary here. Strict scrutiny is a form of judicial review that courts use to determine the constitutionality of certain laws. To pass strict scrutiny, the legislature must have passed the law to further a compelling governmental interest and must have narrowly tailored the law to achieve that interest. In other words, why is it that the city felt that they needed to restrict these words essentially on the sign, and what purpose is it that's advancing the compelling governmental interest? And if you want to read it, it's right up there. So going back on that obviously there was a lot of concern amongst the planning community throughout the country. You know, this is going to change a lot of things. So doing some research into that, staff found a lot of information. The entire planning magazine for February 2016 was dedicated to signs, and a lot of that was about Reed versus Gilbert. And one of the comments that they had in that article was this quote here: "The regulation of non-commercial signage that differentiates on its face between viewpoints, types of messages, topics, or subject matter is likely to trigger strict scrutiny under the holding of Reed. Few sign codes are completely free of those kinds of distinctions, so planners are advised to scrutinize their sign code and replace them as they are found." So that's kind of a general, broad blanket that says, look, you might have problems with your sign code, let's take a look at them. So that's what staff did. I had been kind of marinating in my mind the concept of a form-based sign code, and I don't know if everybody's familiar with form-based zoning. Talks about what the building itself looks like rather than the uses are within it and how those are regulated. My thought was, well, let's do the same thing with a sign code. So even before the Reed decision kind of made its way through the consciousness of the planner world, I had this idea in my mind that maybe we could regulate signs using a matrix, using a chart essentially, on how we can just go through and say, you know, X, Y, and numbers, and more of a rational way of having it rather than a bunch of paragraphs that people have a hard time understanding. So my thought was to do a sign type matrix. So the Reed decision comes up, and we discussed as staff the ramifications of that, the nationwide effect. We went to the APA conference, some of us national conference, there were discussions about that. How do we handle this? And so we expanded the scope as staff to include the full sign code, which includes permanent signs as well. And so how do we put the permanent signs into this same matrix? There are different regulations and different ways that we need to look at permanent signs versus temporary signs. The Association of Washington Cities produced a model sign code that if you are a member of that group, and if you paid a certain amount for dues, that you can take advantage of that. So that's something that we're looking at possibly doing as well. It's a model sign code that addresses all of the Reed versus Gilbert issues, and then looking at applying our matrix to that and coming up with kind of a hybrid. So the form-based sign code itself, is it a new concept? I haven't found any evidence of anybody else doing this, so we're kind of flying off into new territory here. Honestly, when you think about it, it sounds a little bit different and a little bit crazy, but it's not that huge of a departure from what it is we're doing already. We're not talking about making radical changes to our sign code and making it so that signs are now not legal or differently regulated. We're just presenting it in a different way. So the concept was seemingly strengthened by Justice Alito's concurring opinion that included a non-exhaustive list of some rules that would not be content-based. size, location, lighting, fixed versus changing messages, private versus public property, and commercial versus residential property. And you'll see some of these concepts come up when we go into the matrix here in a minute. So as I mentioned before, the sign code in Oak Harbor will not be radically changed. We'll still have the same number of signs allowed. We'll still have the same sizes allowed, things like that. This is not to go in and change, like I said, how things work in Oak Harbor. It's to change how we present that information. So the form-based sign code, it includes a graphical expression of sign types. That's how I'm explaining it. Now we got some different graphics there that I came up with previously and have kind of just put on there to show you some concepts of how this will all fit together. So for instance, you can recognize that the sign in the upper left-hand corner might be used as a real estate sign, but we're not regulating it that way. It doesn't say for sale on it. It says that it's 9 square feet and it's made in a certain way. That's constructed in a certain way out of certain materials. So we're talking about the size and the type of the sign, not what's on the sign. So we combine that with the matrix that provides the regulatory information that goes along with it. So the First Amendment to the U.S. Constitution guarantees freedom of speech. Everybody knows that. But the freedom of speech clause of the First Amendment is not absolute. Instead, the U.S. Supreme Court has repeatedly ruled that state and federal governments may place reasonable restrictions on the time, place, and manner of individual expression. So the guiding principles for our sign regulation within this form-based code include that, time, place, and manner. It's very important. So I know this is tiny, and it's probably really hard to read, and I will give you a hard copy if you would like
So
that.
time,
Yes.
place, and manner,
Yes.
consistent throughout, has to be the same for everyone?
Yes, yeah. So I'll relay that all back together for you. So as you might be able to see on the left-hand side there, there's a column of vertical letters that say time, place, and manner on them. So the top one talks about the time limitations, time, right? So for temporary signs, you have that first group there, the A, B, and C type signs in that darker temporary column there. And it talks about the amount of time that we would allow those types of signs. And what's missing here is the pictures above that describe what those signs are. And that's where we're working to plug these things in. So you have 30 days that say, for instance, that's a sign that you might put in your front yard to advertise for a certain political candidate. But we're not saying that. We're just telling you that the sign that might be made of corrugated plastic on metal spikes goes in your front yard, and you can have that. And that's how long you can have it for, and that's where it's located. So you have time, place, and manner. You have place will restrict the number of signs per parcel based on if you're in a residential or a commercial zone district. We'll say where it can go. Essentially, that it can't block traffic. You can't, impede the safety and the health, safety, and welfare of everybody else. There will be criteria that will be common to all signs, but there will be specifics based on the sign type and what type of sign that is. So you go down and then you see manner, and manner is talking about the size, the height, the materials of the sign, and how it's installed. For instance, if you have a sign type A there that can be there for 30 days, you can have one per commercial and industrial property. You can't have them on a residential property. They must be on the private property with the owner's consent. It has to be less than 9 square feet. It is made of non-permanent materials such as corrugated plastic, cardboard, paper, paperboard, non-rigid plastics. And it's attached to a permitted building or fence. That's your sign type A. So instead of saying this is a banner that says you're having a sale for your business, we're saying that you can have this sign on your business, and this is what it looks like. I'm missing it again. Can you just...
One of the references you made was like a political campaign sign. Isn't that regulated by the federal government?
It is, and it's regulated through the Supreme Court decisions and going back through all the previous decisions that were made by the Supreme Court and various different courts, that's kind of where we're at, that you are allowed to make statements, but you can't discriminate how those statements are made based on what the content is, unless it's obscene or it causes injury to somebody else or something along those lines.
But there's no direct federal law
Right.
that tells local jurisdictions how to regulate political signs. So what Ray is referring to is case law that tells us how we can or cannot limit certain types of speech, but there's no federal sign code that we're obligated to follow.
We haven't got to placement yet, right? Easements, city easements?
I'm not bringing that up, but that's something we can definitely discuss.
Okay.
Yeah. Okay, so as noted in the matrix, the key concept of time, place, and manner is addressed specifically in that left margin. This expressly addresses the constitutional concerns, and there aren't any regulations outside those boundaries. So every regulation that we have regarding how a sign functions, where it goes, is based in that time, place, and manner category. The time, again, refers to the amount of time a temporary sign may remain in a particular location. The place outlines the specific number of a particular sign type that is allowed per parcel and where they may be placed upon the parcel. The manner discusses the way in which the message is delivered, what the sign is made of, what the dimensional limits are, and how it is placed on the ground or on a building. Now, permanent signs are a little bit different. They're similarly categorized by the design and what it's made of, where it's located. The matrix is very similar to that temporary sign section we just looked at, with the exception of the time category, which is not needed. Now, we can't convey all this information using our matrix in a chart. Obviously, there's still going to have to be paragraphs that talk about other standards that just don't fit in that. So not all sign regulations will be able to be neatly categorized within the matrix. There will still be sections of text addressing topics like standards for all signs. All signs must not be obscene. They have to be maintained properly. They can't have just an old ratty sign just hanging off your building. It needs to be maintained. And then locations that do not cause safety issues or nuisances. Also talking about permits and fees, the administration, enforcement, non-conformance of existing signs, definitions, et cetera. There will be still text in this. It's not going to be just pictures and charts. So the ultimate goal of the new sign regulation, just taking some text from our existing code. The purpose of the code is to protect the health, safety, property, and welfare of the citizens of the city of Oak Harbor by establishing standards for the design, placement, and size and maintenance of all exterior signs and sign structures in the city. That's going to remain the same. Like I said, this is not a radical change to our sign code. We're still doing the same thing, just presenting it differently. Number two is compliance with Reed versus Gilbert and any other applicable court decisions that have come before or may come after. Not creating new non-conforming signs. We don't want to have a situation where we're creating a bunch of non-conforming signs because of something that we changed. We're going to go through and vet this and make sure that it doesn't cause that problem. And then developing a user-friendly system for sign regulation that is easily understood for all citizens and businesses. That's really the key thing. The reason that I came up with the concept of having this structure, essentially, is so that somebody can look at the sign code, a business owner or resident, and just say, okay, well, I'm in box A, and I can do this here. Instead of having to go through text and figure out legalese and try and muddle their way through it. It's difficult, and we understand that. We're trying to make it easier. So where do we go from here? What we're looking at is developing the rest of the regulations to fit within that matrix, developing the graphics that go along with that. The ones that I showed you previously are not working.
Go to the next slide.
We'll go ahead and apply that to all the sign types. So it will be graphically represented. You will be able to look at whatever sign it is you want to do for your business. It will give you dimensions, it'll give you materials, and then you'll just be able to follow straight down that column and see what it is that you're allowed to do, essentially. So that kind of concludes my introduction to that. What we're looking at doing is getting this information all put together into a full code format, presenting that to you in the near future. I believe it's November 22nd.
That would be obviously the earliest possible date. We
Yes.
may still have some work to do.
Yeah.
And while Ray has done excellent work here, and it's a very cool concept, I'll note that we still need to survive the strict scrutiny of the city attorney before we finalize this.
There's no time constraint on, I mean, we don't have to put this in place anytime.
We don't, although what we're starting to see is that it's becoming a little more problematic for us to deal with sign code enforcement questions which come to us because we know that we have this disconnect now. I mean, we know what Reed versus Gilbert is telling us that we can and can't do, and we know what our code says. And when somebody says, well, I have a concern or an issue about this sign, it's difficult for us to proceed with an enforcement action when we've got this disconnect. So there's no state mandate, but there's a practical push to us to get this done.
In other words, you can't, by definition, there may be things in the code right now that you really can't cite and
Right.
stand behind.
Right. And so I think we're motivated to get this project done, but that our motivation obviously will not short circuit the amount of time that you folks have. If we need to, come back a couple different times to make sure we have it right, we want the product to be right.
I just have a couple comments. I mean, I think that you're really onto something with this revision. It's really brilliant. I mean, when we initially started hearing about this decision coming down and we're like, oh, we're going to be sitting inside and code conversation again, I think this is really thoughtful, and I'm really impressed. And secondly, I'm wondering what the town of Gilbert's sign code looks like today. Any chance we can just grab a hold of that and see what they're doing?
I'll tell you what, I'll get that information and provide it to anybody that wants to see it.
It's probably really been wordsmithed by some legal attorney.
Great job.
Thank you, appreciate that.
Thanks, Ray.
I do have a quick comment. Currently, as our code exists, there are some requirements for civic organizations that are doing events in town that limits the number of signs they can do, sizes, and that sort of thing that are not very broadly followed or enforced. And it has really hamstrung the groups who have tried to follow the rules and are playing fair. And I think that has been very limiting to those organizations. And I would like to see, I know you're not looking for a major code redesign. However, I think it would be a good point to look into is allowing those civic organizations that are doing community events and fundraising type events to have a little bit more flexibility and something that is enforceable to those that are not playing fair. Would be a good
So
thing.
you're talking about a maybe 32 square foot banner that doesn't say anything on it.
Well, limiting a sign to only the location that the event is going to be held. For instance, an event being held in Windjammer Park by a local organization, that organization is now limited to only having 2 signs on that site, which does not generate any traffic for the organization and also poses other problems of putting a sign on public property rather than putting it on the highway where it gets higher visibility, can't be placed on private property, must be placed on the event site. I think there's some limitations that really hamstring organizations that are trying to do good things for the community.
Sure.
And I think that needs to be addressed when we
Yeah.
move forward.
And
So
we-
do you mind if I jump
Yeah,
on?
go ahead.
So that's an excellent example of the complexity of the problem. So when we last visited the temporary sign code, as a result of dealing with the political sign problem that we had within our code, it became horribly complex. And I think your fellow commissioners at that time wanted us to be able to allow a lot of signs for civic organizations who are doing good in our community. Problem number one, as you've already figured out, is that we were identifying it by the type of the people that were involved, right? And so, as Ray has pointed out to us, we can't do that now. Problem number two is it brought in off-premises signs, which we typically, our code doesn't allow, except in a very narrowly tailored way. Problem number three, you pointed out to us, we've got some people who are following the rules and some people who don't follow the rules. What I think we're really anxious for at the staff level is that this new code will give us a chance to reset the community expectations. And we envision a fairly extensive public outreach effort to try to help everybody understand what those new rules are so that we can have a level playing field. And I guess my last point is we'd absolutely be looking to the commission for thoughts and recommendations about setting aside who's doing it, but of a particular type of sign, what is an appropriate number of them, and what's the appropriate placement of them within our community, regardless of the type of event. So that's a great example, or a great cross-section of some of the issues that we deal with in this particular code project.
Another one of the issues, I think, the enforcement piece of it, there's nobody assigned that duty. It's like a part-time, or that person does something else. It's not exclusively enforcement, like a code enforcement officer or...
It is a responsibility that rests downstairs with our building division, but we do not have a person on city staff who is 100% code enforcement. That is true.
That's part of the problem right there, is you don't have anybody doing that job exclusively, whether it be public nuisance signs, banners, whatever, junk cars, all of that. There's no one assigned to do that. And that, I think that's where Gilbert got in trouble, is that they were doing the enforcement. Probably the signs in Gilbert now, they're probably doing no enforcement at all, trying to stay out of court and trying to stay out of problems.
If you allow just one slight correction, it's not that nobody is assigned to it, it's that we don't have a person who's dedicated to that activity. So we certainly do have code enforcement function within the city.
Right.
And that duty is split amongst, in terms of the things we're talking about, between two individuals downstairs, but it is not their primary job function.
Right.
Yeah.
And
Steve,
also,
would it be fair to say that basically comment from the citizens might trigger taking a look at, in other words, I don't believe we have the resources to send somebody around Oak Harbor every day to look for violations.
We don't, and
That's
it's an
what I'm
excellent
trying to
point.
say.
We use, our process is complaint basis.
Complaint-based.
And so we don't drive around town looking for code violations, with the exception of when we see a life safety issue, we obviously take swift and immediate action. But in terms of something like too many signs or misplaced signs, something that's not consistent with our current code, we don't proactively address those. We respond by a complaint-only basis. So we're going to come back maybe at the regular meeting in November, and we look forward to working with you to finish off this code amendment.
And you mentioned that the matrix would be available to us
I can provide that
see,
to you
since
as well.
we couldn't really read what was
Yeah,
up there.
sorry about that, yeah.
Can you provide us the diagram, the little legend of what the different sizes and signs were?
Yes,
Also.
yeah, and something to keep in mind about the matrix too is it's generalized. It's not specific for what our current code says. It's more of just a concept. This is entirely conceptual. I'll write that on there so you know that. But
Only
yeah,
a
I mean,
draft,
it's,
but conceptual.
yeah, I'm not saying that you can only have one of these signs that can only be this big. This is just conceptually how it would work. So, yeah.
Thank you, Ray. The next item this evening is the annual comprehensive plan amendment. This is also a public meeting. Development Services Director Steve Powers will lead us through this.
Thank you, Mr. Wassinger. I'm sort of pinch hitting for CAC this evening. It's time to kick off our annual comprehensive plan process. Yes, we just adopted the comprehensive plan in June. For veterans of the Planning Commission, we're actually sort of ahead of the game because we're usually about this time of year when you're wrapping up that work. But as you probably recall, or are learning this evening, we have an annual process, and in order to have that process take place in 2017, we actually have to start it here in the tail end of 2016. And I know that you're very familiar with the memo. What CAC has done for you is to outline the requirements or where those requirements come, where our process comes from. When we talk about the comp plan amendment cycle, it's in chapter 1815. of the municipal code. I won't go through that for you in any detail. This is not a major update like we just completed, obviously. This is more of a, for lack of a better phrase, a minor update. We will bring forward to you those amendments that staff is aware of that we probably need to be pursuing. I believe we've started the advertising process so that the public knows that we're beginning this. So there's an opportunity for the public to suggest amendments either to the land use map or to the comprehensive plan document itself. And there are different rules as to how we go about that. We also invite suggestions and topics from the Planning Commission, and we'll do the same with the council. Eventually, we'll end up with what is known as our docket. Think of it as the official work program for the comprehensive plan for any particular cycle. And then we'll go about attacking those projects. The things that we anticipate coming from the staff side, as you know, we have a requirement to look at the capital improvement plan on an annual basis. And so we will do that. Two that we see that are on our horizon. One, the economic development element of the comprehensive plan. We're not suggesting at this stage that we have any idea about what changes may be necessary. But since we only do this cycle once a year, we thought it's wise to put it on the docket so that if a change is necessary, we've at least have it on the list of things, and then we can jump in and have that conversation about what might need to be changed in there. The other one that we know for sure that we need to be tackling is the Parks, Recreation, and Open Space Plan. And since that plan then informs the Park Recreation Space element of the comprehensive plan, that's where the amendment really comes into. And we definitely need to update our parks plan. And so we'll start that effort here this fall, actually. So those are the three things that we know will be coming. I don't think that we have anything else that's needs to be mentioned. I think we provided for you a copy of the advertisement that we've provided to the newspaper. And we will continue working with you to develop the list that you'll send along to the council. I'd be happy to help you with any questions if you had them.
Will there be any other announcements going out, or do you typically just do one?
No, I think I think we do another one as well, and we, I think, are always on Channel 10, and I think we're on the website, but we're open for suggestions. If the commission has other ways that you think that we should be informing the public of this, please just let us know, and we'll do our best to accommodate those suggestions. Not particularly exciting at this stage, but it's an important procedural step, and so I guess it's exciting to us. Thank you for your time.
Thank you, Mr. Powers. Just a reminder that the special meeting is scheduled for November 9, 2016, and I believe that's a Wednesday, and that the next regular meeting will be the fourth Tuesday, November 22nd. Anyone have any further comment? If not, meeting's adjourned.
Good meeting.